Moving on now to discuss the institutional prospects for enforcing international human rights law through international criminal law, the most natural and in fact most frequently invoked basis for holding to account international human rights law violators through a criminal process is the exercise of criminal jurisdiction by what is called the natural jurisdiction state. That is the state in which the crimes have occurred, or the state of nationality of the victims or the perpetrators. Such states normally have an independent interest in pursuing the case, other than the international interest in combating impunity. Moreover, the exercise of jurisdiction in such cases is well established from an international law perspective. There is plenty of authority in support of the legality of territorial jurisdiction and of the principle that states can prosecute their own nationals or those who committed crimes against their own nationals. The importance of the 1961 Eichmann case in Israel has been to put forward the proposition that war crimes, crimes against humanity, and genocide are in fact international crimes over which jurisdiction is universal. Therefore, the very nature of these crimes serves in itself as a basis for a jurisdictional title. Moreover, like with the case of piracy, the trying state in these cases is acting on behalf of the international community as a whole. This universal jurisdiction approach was boosted after the 1999 Pinochet extradition decision by the House of Lords in the United Kingdom, where it was held that torture, being a jus cogens norm, namely a fundamental norm of international law prohibiting torture, entails universal jurisdiction. In that case, the court suggested that there could be no immunities, including the immunities of a former head of state, that would be compatible with the fundamental nature of the underlying norm prohibiting torture. It is important to note that the Eichmann trial stands for the proposition of a right to exercise universal jurisdiction. Still, post-1948 treaties did go beyond that, and not prohibiting the exercise of universal jurisdiction, the 1949 Geneva Conventions actually introduced an active, a positive duty to prosecute or extradite war criminals, o dedere o judicar in Latin. Either you extradite or you try. And similar formulations are also found in other treaties such as the Torture and the Terrorism Conventions. The combined effect of the doctrinal acceptance of universal jurisdiction and of the treaties requiring its application has pushed a few dozen countries around the world to adopt universal jurisdiction laws. Still, despite the best intentions of academics, NGOs, and practitioners, the last 2 decades have largely represented a reversal of fortunes for universal jurisdiction. For instance, following a threat by the then Secretary of Defense for the United States, Donald Rumsfeld, to move out the NATO headquarters from Brussels if legal proceedings would take place under universal jurisdictions against United States officials in Belgian courts, Belgium revised its universal jurisdiction laws and removed its more ambitious universal jurisdiction contexts. A similar dynamic has recently played out in Spain, where universal jurisdiction laws attracted considerable international support as long as they addressed events in Guatemala and Argentina. But once Spanish magistrates started looking at events in Tibet, Guantanamo, and Gaza, and also at the crimes of the Franco regime, pressure was put to bear on the country's judiciaries and parliament, and the laws have been changed so as to insist on a Spanish connection to the crimes in question. The United Kingdom has also revised its universal jurisdiction relating procedures following attempts to arrest in the United Kingdom Henry Kissinger, senior Israeli politicians, and the former Bosnian president, following an extradition request by Serbia. And now the law limits the power of individual judges to issue arrest warrants in such cases. The upshot of all of this is that universal jurisdiction, which was never too popular of a doctrine in practice, since universal jurisdiction trials are complicated and expensive, has generated over the years considerable diplomatic and legal backlash, and states are increasingly reluctant to unilaterally assume the costs of international law enforcement for the entire international community. Hence, although some universal jurisdiction trials continue, recent proceedings were initiated in Switzerland and Germany relating to events taking place in Algeria and Syria. There is clearly an interest by policymakers in moving the emphasis of the fight against impunity from universal jurisdiction to international jurisdiction. International courts offer not only the attraction of shared assumption of costs, economic and political, but also greater political legitimacy. And as a result, greater impact on deterrence and on the ability to remove international criminals from power. Like with other international law trends, one can see here a move from the horizontal interstate enforcement machinery to a more vertical, like centralized form of enforcement. The first precedent of an international criminal tribunal is the International Military Tribunal in Nuremberg, which we've already mentioned, and the parallel tribunal that operated in Tokyo and was established by the victorious powers in World War II. Early attempts to build on the relative success of Nuremberg and to create a permanent court have faltered because of the Cold War, and indeed only at the end of the Cold War was it possible to activate the Security Council and to create ad hoc international criminal courts for Yugoslavia and for Rwanda. In both cases, the legal basis of the jurisdiction of the court was Chapter 7 of the United Nations Charter that gives the Security Council extraordinary legal powers to deal with situations of a threat to world peace, breach of world peace, and situations of aggression. And the claim made in those cases was that there is a link between impunity in violent ethnic conflicts and the general state of world peace. Although the ICTY, the Yugoslav Tribunal, and the ICTR, the Rwanda Tribunal, have been successful in reviving interest in collective enforcement of international criminal law and have made some real contribution to stabilizing the situation in the Balkans, mainly by way of encouraging some restraint on the ground and facilitating the removal of warmongers from power. They also supported some notions of accountability in Africa, although the ICTR has been criticized for applying the law in a one-sided manner. The ad hoc model is flawed. It represents selective justice, and the operationalization of such justice is slow and costly. Arguably, stronger deterrence can be generated by a permanent institution, and the 1998 Rome Statute is a response to such criticism, the establishment of a permanent judicial body with a potentially universal mandate. The ICC is also a complementary legal body. It operates only when states are unable or unwilling to prosecute mass atrocity crimes, namely war crimes, crimes against humanity, genocide, and aggression crimes. The Achilles heel of this ICC system is, however, its treaty-based jurisdiction, which allows states to refuse to opt into the system. So far, most states, but not all states, 123 states, have ratified the statute. Hence, with regard to nationals of non-state parties, the court can only exercise jurisdiction if the crimes occurred on the territory of a state party that has accepted the statute or consented to jurisdiction, or pursuant to referral by the Security Council, as was the case in Sudan and Libya. Mass atrocity crimes such as those occurring in Syria cannot unfortunately be addressed by the court, since all relevant countries here, including those countries that hold veto power in the Security Council, oppose to the jurisdiction of the court. Furthermore, the ICC only has jurisdiction over crimes that were committed after the court was established in 2002, and for many countries, only after they had joined the statute, and its jurisdiction is, as indicated, only with regard to 4 mass atrocity crimes: war crimes, crimes against humanity, genocide, and the crime of aggression. The notion that the primary responsibility for international criminal law rests with national courts related to the crimes has also generated since the late 1990s a new category of courts, that is hybrid courts, namely courts that are created jointly by international and national authorities, and typically involve the application of national and international standards by a mixed panel of judges and a mixed staff of lawyers, national and international. The paradigmatic version of such a hybrid court has operated in Sierra Leone, and one can also mention in this regard Cambodia and Lebanon and the Lebanese trials, which are based on a more or less hybrid model. A number of other institutions created in internationally administered territories such as East Timor, Bosnia and Herzegovina, and Kosovo operate along a similar logic. The advantage of the hybrid model is the greater local legitimacy that such courts may confer upon the legal proceedings. They also cost less and have some capacity building potential for the new states. Still, their creation is feasible only in transitional cases where a new government is interested in promoting accountability. At the end of the day, it is important to remember that the capabilities of international criminal tribunals in all their forms and shapes are quite limited. And in fact, the number of cases they deal with per crime scene or investigated situation has been over the years in sharp decline. They address more and more only the top perpetrators in each mass atrocity crime scene, leaving behind seriously accountability gap. So, whereas, for example, the ICTY and the ICTR dealt with dozens of perpetrators, the hybrids with courts with significantly smaller numbers, and the ICC is dealing only with a handful of perpetrators per crime scenes. Therefore, international criminal law, as applied by international criminal tribunals, should be viewed only one among numerous measures for addressing mass atrocity crimes. Furthermore, even the criminal law objectives of international criminal tribunals are controversial, and some experts do question whether meaningful deterrence can be generated at the international level. Finally, it has been commented that the turn to international criminal justice may result at times in lost opportunities, either failure to engage in humanitarian intervention or complication of peace efforts, where in those cases where immunity can be traded for a shift of power. It is not certain that from the perspective of victims of mass atrocity crimes, criminal accountability, which often does not lead to meaningful reparations and at times prolongs conflict situations, is preferable.